Right now at 4, a North Carolina Superior Court judge is set to hear a death row case that could affect other claims made under the state's Racial Justice Act.
Hassan Bacote, who is black, said race played a role in the selection of the jury that ultimately found him guilty of murder. Bacote was sentenced to death in April 2009 after he was found guilty of first-degree murder in the February 2007 death of Anthony Searles during a robbery in Selma. Today, Bacote's attorneys talked about the significance of the upcoming hearing this Monday and its implications for all death penalty cases in the state.
This will be the first case and the only case in the country, really, to go forward under this. It's unprecedented. Related to that, in addition to being a unique law, is the fact that, of course, this is the first case to be litigated that will have precedential value. So this is the case where the judge will make decisions about the scope of the law and also will make findings of fact. Is there discrimination statewide in jury selection in North Carolina?
What we have is the advantage of a scientific, statistically sound study of every capital case from 1990 to 2010 in North Carolina and in Johnson County. And what it demonstrates is Black citizens that show up in response to juror summons are excluded from service at a rate twice that of their white neighbors. In Mr. Bacote's case, that rate was actually 3 times.
So clearly a very interesting case here. So let's bring in Queen City News Chief Legal Analyst Khalif Rhodes.
And Khalif, first off, explain the Racial Justice Act that's in play here.
Well, let me go ahead and say this. It was not even a law anymore in North Carolina. In 2009, Democrats had control of the General Assembly. They came out with something that I thought was ahead of its time. Folks were like, listen, we need to do something that can right the wrongs that were done by race. And if you could point to race being the reason why you were convicted, you had a reason to get off the death penalty and maybe get your case thrown out. Fast forward to 2012, Republican-held General Assembly, they said, wait, not so fast, and pushed back the folks even filing a claim. They removed the law, so this law is not even in fact. Folks had to challenge it to the Supreme Court to make sure that they could even get access to that law when they filed it. The Republicans at that time wanted so bad for this law to be erased. They said if you were one of the 130 people that filed claim, your case couldn't even go forward. The Supreme Court at that time said, well, those guys already filed it during the time when the law was the law. They need to go forward. That's why we have these 130 people that have claims. And Mr. Bacote is one of those folks that got his case in there before the law was repealed in our state. But this law protects individuals that were done wrong through all the legal system.
Well, and this was a long time ago, 2007, when the crime allegedly happened, and the hearing just now is happening this upcoming Monday. What kind of evidence do you expect to be brought up here?
Well, this is going to be the portion that everyone sees in the movies. You're talking about the voir dire process of jury selection. As someone that does homicide cases, specifically capital offenses where folks are facing the death penalty, I'm extremely familiar with this portion of the process. And so these cases are extremely unique. And so when you're selecting a jury, you're talking about preemptive challenges and challenges for cause. Preemptive challenges, I can challenge you and get rid of you for anything. I don't have to say I just didn't want you and I have a certain number. Also for cause, I have to point to a reason. What they mentioned in our intro was that study they got from the University of Michigan, it said that in North Carolina, prosecutors used systematic processes to ensure that they got Black folks off of the juries every time, disproportionately, like 90+% in that one county. Those are rationales and reasons why that law was put in place to stop something like that from happening. I have to add, that man said it best. I couldn't have argued it any better. Folks showed up. They did their constitutional duty to show up to be a citizen, to sit on a jury, and these prosecutors were going out of their way, the statistics show, to make sure that Black folks didn't have an opportunity to sit on those juries. That by itself is the reason that we're here. And I believe if the Supreme Court listens to the evidence that is presented before them, that individual at the very minimum will be removed from the death row for sure.
Say they do overturn it. What's the precedent that will be set here then?
I think going forward, you'll have at least other cases of the 130 that filed within the state of North Carolina. They'll have an opportunity for their case to have a precedent of the Supreme Court saying that we read the science, we saw what was submitted in front of us, and we do believe that you were disadvantaged and you were a bias was set based on your race, and that because those reasons, you should not at least be subject to the death penalty. It doesn't mean that their case will be overturned. overturned. It doesn't mean they will be free or released, but it will say that most of the time in our state, the death penalty isn't even an option. In these cases where the DAs have decided to seek the death penalty, if your case was at somehow disadvantaged because of your race, you should, at the very minimum, not have that be something that is in front of you anymore.
All
So
right.
a lot of implications, and we'll tune into that hearing
Yeah.
on Monday. Khalif, thank you.